Closing a small estate. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 590. Scale for State Court Administrative Order, PC for Probate Court, Form 590. You're welcome to contact my office. We'd be happy to provide you with a copy of this form free of charge. Now understand the context of this form. As you can see from its title in the red rectangle, it's a sworn closing statement, summary proceeding small estate. This form should not be confused with the sworn statement to close that's used generally in estate administration when it's being closed informally, meaning not with a petition for complete estate settlement. In fact, this form is used in a very small number of cases in which the estate has minimal assets. The estate has been opened and it is being closed under a particular set of statutes for summary proceedings. Now, with all of the scale forms, they are created or give rise to the form by virtue of various statutes and court rules. And here with that floating arrow at the bottom right, you can see that that's MCL 700.3205, MCL 700.3988, and then the court rule MCR 5.311A. Now, with all of these scale forms, we urge you to be working with a skilled, competent probate practitioner so that you understand how to use the form, when to use the form, and the interplay between the statutes and the court rules. And again, this particular form is used in deceased estate probate administration, in which you're closing it by summary proceedings, a small estate, minimal assets. Let's work our way through the document. In the top left corner is the county in which the probate is situated. In the top right corner is the case or file number. At the top, pretty simple here, the estate of, the name of the estate upon which the probate is being administered. And then there's these assertions within the beginning paragraphs. Number one says that you're the personal representative. And when filing this sworn statement with the court, you're asking the court to close the estate without a hearing. So again, this is an informal way of closing an estate versus a formal way in which you're asking the court to conduct a hearing and make an adjudication on the petition, the accounting, the schedule of distribution, and so on. Number two is very common in these scale forms. You're identifying whether there's been any change in the interested persons from the estate from the original application or petition that was filed. So again, constantly updating the court as to who is entitled to notice of the proceedings that are occurring through probate. This allows for any changes in identification of interested persons as well as addresses to be assured that notice is provided appropriately. Section 3 indicates that you're making an assertion that the estate is not under any supervision and has not been prohibited by a court order from filing. So for example, if the letters of authority have a restriction or there's a court order that provides for a supervised administration, this form would not be allowable to be used. You'd have to close it either formally or through a sworn statement to close, depending on the circumstances. Again, understanding the form and its relation to the entire process as well as the statutes are really key here. 4 provides this assertion that the estate, the value of the entire assets within the estate, less the liens and encumbrances, these are the debts or security interests that are on the property, does not exceed administrative costs and expenses, reasonable funeral and burial expenses, homestead allowance, family allowance, exempt property, and the reasonable necessary medical and hospital expenses of the decedent's last illness. That's a mouthful. And it says that the value of the estate is shown on the inventory. Remember, in this probate administration process, there's an inventory that's either presented to the court or filed. So the total value, less these liens and encumbrances, does not or is less than such that it meets the threshold such that you can use a small estate closing. Now, the beauty of this is there's no need to publish in those circumstances, and the money can get distributed without the formalities that are often required in a full probate administration. The exemptions and allowances are covered in another video that I've done, and there's statutes that guide how those exemptions and allowances are entitled to be paid out. In addition, administrative costs and expenses and funeral and burial expenses I've also covered in other videos, but understanding the statutes is really key here. So there is still an inventory. You've opened the estate, there's still an inventory, but then you're closing the estate through a summary proceeding, a shortened proceeding that allows the estate to get closed because the amount of value within the estate doesn't reach over a threshold. Because remember, in estate administration, there's like a pecking order, a prioritization of how things get paid depending on the value of assets within the estate. Number 5 provides that you fully administer the estate. You've done everything that is required under the statute and court rule as it relates to dispersing and distributing the assets to those persons that are entitled to it. 6 provides that you're providing a sworn copy of the sworn statement to the distributees, the interested persons within the estate, and any creditors. So remember, even though those creditors may never see a dollar, may not get paid, the statute mandates that they also get notice of this filing. So creditors and claimants and demandants, that's a kind of a fancy term for those making a demand for payment, of whom you're aware. So remember, you may not have published for unknown creditors, but if you're aware of those creditors, you're going to give them notice of this sworn closing statement summary proceedings to let them know that the estate has not crossed over that threshold and that you're closing it by a summary proceeding. Here there's a space for the person representative signature, address, and so on, pretty basic, and then a notarization. Notarization block to acknowledge the notary acknowledges the signature, and then if there's an attorney involved, the attorney's signature. The bottom section provides for that notice the opportunity to object. And you can see here, you can pay a filing fee and object to this proceeding being closed in this manner, which would then trigger an opportunity for a hearing on how the estate is being administered. In addition, if no objection is filed within 28 days of this, sworn statement to close being filed with the court can then issue what's called a certificate. It's a certificate of completion that indicates that the person representative has performed their role and fully administered the estate. Now, it doesn't preclude the estate from additional activities because there are some rules within the statutory rules that allow for additional things to occur thereafter. But again, a full understanding of how this form works in conjunction with the statutes and court rules are really critical to understanding its appropriate use. At the Probate Pro, we're passionate about everything probate. If you have questions about the sworn closing statement, a small estate, or anything probate or trust related, give us a call, 1-833-PROBATE, or visit us at theprobatepro.com.